Under the 2007 Construction, Design and Management Regulations, legal duties are placed on virtually all parties involved in construction. And like clients and contractors and CDM coordinators, designers are also duty holders. Well, in this programme, we're going to run through a number of HSE-backed top tips that designers as responsible duty holders should heed. And to guide us through designers' health and safety obligations, I'm delighted to welcome Giles Meredith of the HSE and James Ritchie of the Association for Project Safety. Well, let me start with Giles first of all. Giles, give us some of the Health and Safety at Work Regulations Act background to this before we start.
Well, the main piece of law that relates to health and safety in the United Kingdom is the Health and Safety at Work Act, and all the regulations really fall from that, and that lays out essentially the responsibility that people have towards workers and other people who are affected by the work that they do. So it applies to architects and designers as much as it does to anybody else.
And of course we're talking about a legal obligation here.
Yes, absolutely. There are legal requirements and other regulations which obviously relate to construction work as well, such as the worker height regulations, the things that architects should and I'm sure do know about.
Good. Well, we've got a few top tips. Let's look at the first one, and that is appointment. The appointment. Once you've been appointed, be certain that you've made sure that all parties, and that's including the client here, are aware of their CDM responsibilities. Where a project is likely to become notifiable, that is, require more than 30 days' work or 500 person days of work, don't proceed past RIBA Stage C until you're absolutely certain that the client has appointed a CDM coordinator and you know who that is. Last year, a Bradford-based contractor was prosecuted by the HSE after a worker was seriously injured in a fall at a site where it was principal contractor. Well, as well as breaching Work at Height Regulations 2005, it also pleaded guilty to a charge of failing to notify the HSE that construction work was due to take place. The firm was fined £5,000 and ordered to pay costs of £1,800 for both offences. After the hearing, the HSE said, if HSE had been correctly notified that work was going to take place, it could have inspected the site and the injury may have been averted. The measures in place at the time simply did not amount to a safe system of work. So, Giles, it looks like this case boils down to a basic failure to appoint a CDM coordinator.
That's certainly an element of what went wrong with that particular incident. As the quote said, it provides an opportunity for HSE to know what is going on. A lot of construction work is invisible and you simply wouldn't come across it unless you have that resource. And we keep a database of projects that are ongoing. And simply getting the notification is part of the whole process that includes appointing the CDM coordinator, making sure that you have the right competent people. And it's really a trigger so that we know that those things are being put in place.
Yeah, but James, to bring you in here, I should imagine that if you're a contractor, it can sometimes be quite difficult if your client is urging you to press ahead before you've dotted the I's and crossed the T's.
It's quite difficult when a client is urging even a designer to move forward on a project without all of the necessary pieces being in place before work starts. So yes, it is particularly difficult, and in this case clearly the work, some design presumably had been done at some stage by somebody, and yet the project had still got to the stage where a contractor had started on site, clearly with nobody having notified the HSE and presumably therefore no CDM coordinator in place. So the relevance for designers is very much about advising the client properly right at the beginning, because they're very often the first person in on the ground of a project. And if they are advising clients properly, then the client at least is aware that they do have that responsibility to make sure they get good advice and assistance from a CDM coordinator, who would have then ensured that the contractor had not started work on site until everything was correctly in place.
Yeah, and that accident could have been avoided, potentially.
Yes, potentially.
Yeah. Okay, well that takes us on to tip number 2, which is competency. A Shropshire boarding school was recently fined £25,000 after a worker was killed while demolishing a building on the site. The HSE prosecuted Moore Park Charitable Trust Limited, which runs Moore Park School, after it arranged for a team of inexperienced building workers to demolish a large wooden classroom. Mark Evans, aged 40, of Ludlow, suffocated when the classroom roof fell on top of him. Shrewsbury Crown Court heard that Moore Park School had arranged for a self-employed general building worker, who was undertaking some minor roofing work on the site, to carry out the work. He asked 4 other self-employed building workers to assist in the demolition, even though none of them had training or relevant experience. The HSE found that the school had failed to make reasonable inquiries into the competence of the men. HSE Inspector Nick Rigby said this: "Had Moore Park School taken reasonable steps to properly consider the demolition work, they'd have appointed a competent and experienced contractor and avoided the roof collapse." Well, Giles, it's a pretty basic question, but how do you measure competence?
Well, the CDM regulations do help a little in that, and what they try and do is divide competence up into two parts, if you like. Stage 1 looks at things like qualifications and management systems, and the second part is to do with relevant experience. So it's what skills you have that would equip you to do a particular job, horses for courses, I suppose. There have been some issues with people having difficulties having to endlessly fill out forms to demonstrate that they're competent for pre-qualification to get on tender lists, and that's really brought about the organisation of SSIP, which is Safety Schemes in Procurement. And what this organisation aims to do is to make sure that if someone's accredited with one of the accrediting bodies that are part of SSIP, then they will be recognised by the other accrediting bodies who are part of that same organisation. Now, I know it sounds a bit complicated, but it should mean that a client will accept that a designer or a contractor has competence if they've been accepted by an accrediting body, and they won't just ask for their own pet scheme. So hopefully it should cut some of the bureaucratic burden.
So it should simplify things a little bit, but nevertheless there are still a load of forms to fill in. It sounds quite costly. Isn't this just another hoop that architects are being forced to jump through?
Well, it's not just architects that have to prove their competence before they take on an appointment. It's very important that if we come back to the regulations and the duties involved there, you can't take on an appointment unless you yourself have determined that you are capable of doing that. And equally, nobody can appoint somebody unless they are satisfied that the person they are going to appoint is competent as well. So coming back to the issue of bureaucracy, if you like to use that word, and form filling, SSIP is there to let an organisation, a design practice or a CDMC practice or whatever, do it once, get accredited for that, and then they don't have to do it again. So rather than applying for maybe 7 or 8 different jobs with different local authorities or whoever it is that's wanting to know about your competence, you can do it just the once, and then there you are. You can say, well, actually my practice, my design practice, is accredited with X, which is part of SSIP, and therefore you don't have to fill in all of the other tick boxes below.
And are there any alternatives to SSIP which are equally well regarded?
There are other organisations out there that do accreditation systems for the industry, for construction industry. Many of those are aimed at contractors. And to some degree, the whole of this came out of assessment of contractors in the first place, because they were the main body that was through CHAS, Construction Health and Safety Assessment Scheme, that formed the basis of SSIP. So yes, there are other people out there, but there's a myriad of accredited accreditation systems out there, and SSIP is collecting probably the majority of them together into one recognised mutual body.
Okay, so hopefully this will simplify things for people. Let's move on. Let's look at existing risks. So, existing risks. Last year, a Perthshire company was fined after 2 workers were admitted to hospital with acute lead poisoning. The firm pleaded guilty to failing to identify that lead paint was present during a renovation project and also failing to ensure suitable precautions were taken whilst the old paintwork was sanded down and removed. Well, over several months, workers inhaled and ingested lead dust. The dust was also spread on the workers' overalls to their homes, potentially endangering their families. So, James, what should the client have done in this case? And also, what should the designers have done?
Right, well, one assumes that the client might have been slightly naive about construction. We have to remember that with many projects, clients, it might be the first time they've ever done a construction project.
So you can't expect the client to know that there was lead paint there?
No, if it was an experienced client, then maybe they might have known, but one assumes that it might not have been that experienced, and they have almost a right to be able to rely on the competent people that they are appointing to advise them correctly. Now that would be the designers in the early stages and the CDM coordinator, again, to tell them about the building and to extract what information they can about the building right in the early stages. And many of the issues that you really need to know about to prevent these sorts of problems can be obtained very easily in the early stages of design by the client actually commissioning some surveys. A survey on the building to see whether there's any asbestos present, a survey to see whether there's any lead present. And now it was an old building that was being refurbished, and any building before 1970 has the possibility of there being lead in the paint that was used.
But the client might not necessarily be expected to know that. Wouldn't you expect, Giles, that the designer should suggest that to the client?
I think designers are in a good position to make those sorts of suggestions, and they are a body of people who are professionals, who are competent and would anticipate those sorts of issues to arise. So yes, and as we've said, the competencies within CDM are all interlinking, and that's, I suppose, the beauty of the regulations, that if everyone has a level of competence, they know what they're doing, then you can rely on them to do their job properly.
I was just going to say, with this particular incident where it was involving lead in paint, it's a question of, is this a significant risk or not, and did the designer involved on the project understand that there might have been lead, and whether, even if there was lead in paint, did he actually understand whether it was going to be a significant risk? Now, if it had just been one window that was being refurbished or whatever, it might not have been significant, but we're talking here about somebody doing a repetitive process over a series of months, which has led to the build-up of lead. So it's understanding what is a significant risk in a project, depending on the type of project that it is.
And to what extent are drawings involved in that, Giles?
Well, drawings become very important when the designer starts to tell the contractor about what it is they want them to do. And I think more and more designers are using drawings to highlight significant risks that might be present. So the presence of asbestos would be something that would be very useful to highlight on a drawing, because essentially we know that people in the construction industry look at drawings. They're the language of construction, and there's much more chance that things will be taken notice of if they're on a drawing than if they're in a dusty file stuck on the shelf of the site office, which is often the case, or historically was.
Just to underline this point, I would have thought that if there's any refurbishment going on with a building that's how old, at what point was lead paint no longer used?
Well, the end of the 60s. So
in
other words, from prior to 1970 would be pretty much the cut-off mark.
So any refurb before that date, think about asbestos, think about lead paint.
Well, any building that is older than 1970 may well have paint or lead products in it.
And I think also, of course, for asbestos, there is an existing system where you expect, certainly for commercial premises, for there to be an asbestos register. That may be one of the early indicators that might be used for a design. But for major refurbishment work, it will need a new survey, and it'll need to be an intrusive survey to actually find the stuff.
Well, the next 3 tips cover 3 abilities. That's buildability, usability and maintainability. We'll start with buildability. Now, architects aren't necessarily required to specify construction methods, but they should always consider the practicality of installing specified components, their sequencing and advice on how they should be handled. Other logistical issues that may have an impact on health and safety should also be worked through early in the pre-construction phase. These issues include the access arrangements and site setup requirements, such as access to water, power and waste facilities. So, James, it does sound like we're saying architects' designs should be buildable. I mean, really, come on, we're teaching them to suck eggs, aren't we?
Well, you might think we're teaching them to suck eggs. It's not to take away the aesthetics, the sexiness of design that architects like to put into their buildings, but it's about actually just having the thought process of, that's a great design, but how is that going to be realised? Because
is it going to work?
Is it going to be buildable easily? We can look at a number of different public buildings around the country or whatever and say, well, they had terrible problems trying to build that because, was it because it hadn't been thought through properly at an early enough stage? And equally, other projects have been well thought through at an early stage, and it makes the contractor's life an awful lot easier. And let's face it, when it comes to the client's requirements, they're looking at time, cost and quality. A building that is buildable is going to be built easier, safer and quicker. And obviously will presumably therefore come in at better quality and on time.
Wouldn't you just love it if buildings were put together, all prefabricated in a warehouse and just shipped onto the site? Is that what's going on here in a sense?
No, I think that's a slightly simplistic view. There are obviously significant advantages from prefabrication. It can work very well. I think there have been some examples of hospital rebuilds recently where they've had a very tight site and a very tight timescale to deliver those projects. Prefab works extremely well there, but it's not going to be appropriate for all sites, and we understand that quite well.
Okay, moving on then to tip number 5, ensuring the design is usable. Okay, how could one hope that, I should imagine that any competent architect is going to come up with a usable building. Surely you don't have situations where architects don't actually manage to tick that box.
I think architects do occasionally get things wrong. I think architects are actually very good at putting people at the centre of the work that they do, and that's really what we're talking about. But as I say, occasionally it does go wrong. I'm aware of an incident fairly recently where a new school building with a beautiful canopy detail on it was partially demolished by a reversing bin lorry which had to go past the canopy. Now, in that particular example, a bollard possibly would have protected the canopy, but also, do you want to design where vehicles are reversing past the entrance to a school? And something's gone slightly wrong there. So it's those sorts of examples we're really thinking about.
Okay, thanks. Let's move on to tip number 6, maintainability. Now, a recent tragic case illustrates the dangers of not paying attention to how your building can be maintained safely. In this case, an Oxfordshire-based architectural practice was fined £120,000 and charged £60,000 costs after it was found to be partly liable for the death of a 64-year-old subcontractor, David Cairns. Now, Mr. Cairns was working on a platform accessed via a ladder at the edge of a flat roof. The design of the building was such that the foot of the ladder was very close to the edge of the building, demarked by a low parapet wall. Now, Mr. Cairns came down the ladder, but he then fell straight over the parapet wall and he fell 9 metres to his death. Now, this is a terrible case, obviously, Giles, but it was interesting that the architect was fined, well, I've just said £120,000. The main contractor was only fined £75,000. So, that's a very clear message from the courts saying that they held the architect to be more liable.
I think it's quite dangerous to second guess why judges impose particular sentences, but the judge obviously recognised that design was at the genesis of the accident. And one of the interesting and I suppose most significant elements of this particular accident is that there's a legacy issue. The building had been finished and handed over, and it was actually the person who then came to maintain it who came to grief. So it is no architect sets out to be responsible for anybody's death, and it's a tragic incident. But I think it really sends a message that you have to keep on top of the design, and particularly when there are late changes, as I think there were in this case.
Ah, that's interesting, isn't it? So you have to have the same duty of care, James, when there are subsequent design changes.
Absolutely. Any part of design, you have this responsibility for buildability, maintainability and usability. Irrespective of whether it's happening before you get on site or whether it's right in the last dying stages of the construction process, because any change to that design may or may not have implications for health and safety, as this case seemingly unfortunately did. And it's very important also that the CDM coordinator is involved in those design changes, because the CDMC can actually help designers in these instances by looking at what the designer is doing, not resolving the problems for the designer, but at least raising potential problems. And maybe in this case that might have helped the situation and prevented a tragic death.
Indeed. Well, our 7th tip then is to concentrate on significant and unusual hazards. Well, Giles, are we suggesting that lesser risks can somehow be ignored here?
I don't think that's quite right. I think what we're talking about is being proportionate in your approach to dealing with risks. I think if we had a scenario where an architect could deal easily with something which was relatively low risk, then we'd expect him to do it. And I think he would probably not give it a second thought. And it's simply good design. The sort of thing I have in mind is I don't know, designing a floor that's level that doesn't have a small trip hazard. But yeah, we need to be clear that it is the significant risks that we need people to concentrate on, and that's all to do with being proportionate. And then they can provide the information about what risks remain to the people who then have to manage it as the next phase in the build.
But then, Giles, that begs the question: how do you determine what is a foreseeable, what is a proportionate risk? I mean, do you issue guidelines to that effect?
Well, foreseeability and what's proportionate really, I think, needs to be left to an architect's good judgment. I think mostly they're very good at determining that. People have tried to perhaps give a steer to designers on the sort of issues that can be avoided, and perhaps those that can be promoted through red, amber and green lists of
like a traffic light.
Yeah, exactly, a traffic light system. And the advantage there is that we're saying perhaps that things in the red list we should avoid. It may not always be possible to avoid doing them. Sort of things like perhaps designing a road system where pedestrians and vehicles can't be segregated, that sort of thing. And then sort of the flip side of that is the green list has things that we'd actually like to actively encourage, like the opposite of that, a decent transport route where you can eliminate reversing and where pedestrians are segregated from vehicles, for instance.
That sounds like a great idea. Is this relatively new, the red, amber, green?
Well, I think they've been around for a while. There's an example on the HSE website, which is very easy to find. If you type red, amber, green and HSE into your search engine, you'll find it. So, and people can then take that and tailor it to their own projects and make use of it.
Really helpful, thank you.
I think it's important, just on that point, to make a couple of fairly important issues. One is that we need designers, architects like myself, to actually understand risk and risk management sufficiently to be able to make that judgment as to what is a significant risk and what isn't a significant risk, and also then to consider not just about designing out risks, but actually designing in features into their designs that actually will help with the future.
We're nearly at the end of the programme, but before we go, it's worth pointing out that sometimes a hazard just can't be removed. Asbestos, of course, is the obvious one. So, James, what does a designer do in that situation?
Well, the designer in the very first instance should obviously be raising with the client and via the CDM coordinator the need to make sure that they've identified as many of these potential hazards as they can very early in the design process. So the asbestos register, which the client should already have for the building, but if they don't, making sure that you go in, arrange for a proper asbestos survey, and then clearly identifying them on the drawings in the early stages, because it may change the way the building is actually designed. I've worked on a building in the past where we clearly identified where asbestos was, and we redesigned the layout of the building in very early sketch scheme stages to make sure that we didn't actually do anything that was going to disturb that. Because
So you left that in
asbestos,
situ?
yeah, asbestos is fine as long as you're not disturbing it. It's only the fibres coming off it that are the problem. So you don't always have to go to the length of stripping it out just because you found it. But it's then about finding it, identifying it, and making it absolutely clear on your drawings as an architect that here is, here there be trouble, yes. and working your design around that if necessary. If you can't work your design around and get the building to function the way you want it to be, then okay, maybe you can then look at the options of actually taking the asbestos out. But it really is important to get these surveys done very early in the design process so that you know what you're dealing with.
And that kind of thinking, I should imagine, Giles, is exactly what you'd like to see in the industry.
Yeah, absolutely. I think if you can encapsulate what James says and actually get people to start thinking about dealing proportionately and sensibly with risk, understanding it. Architects are well used to talking to each other about their designs, about peer reviewing what they're doing, and health and safety can all be a part of that. And then you understand what the risks are and start to deal with them.
Well, it's been an excellent and very interesting programme. Gentlemen, thank you both very much indeed.
Thank you.
Well, a more comprehensive list of all the sources that we were hearing about earlier from James, the HSE obviously, and many other sources of additional information can be found in the study notes that accompany this programme, so do have a look at those. Until next time, goodbye.